Thank you both. We'll call the next case KLING versus City of Leesburg. Doesn't make any difference which side you sit on.
You want me to approach you?
Hold on just a second, let your opposing counsel get settled in and... All right, sir.
If it please the court, Mr. Briones, Your Honor, I'm Michael Hatfield. It's my privilege to represent Timothy King. I feel like we have briefed the case completely. I'm going to be very brief, but if I could characterize this case, what I see, it was actually put in a synopsis in our reply, and that is if Mr. KLING had traded a vehicle and some boot was paid and he owned the subject vehicle that is sought to be forfeited, and there's a question as to whether it was 2 or 3 days later this vehicle was alleged by the city to be used in a crime that would allow forfeiture. And we deny all of that. In the summary judgment response that they had filed, we filed a sworn affidavit from Mr. KLING, who was a person who was present and therefore had the ability to say what happened and what he would prove if he went to trial. One of those things that I think is the most important to this appeal is that he was the only person who was entitled to possession and use of that vehicle. Then the issue says, well, the case law that you've examined and put in the brief says, well, he didn't perfect his title by getting a certificate of title. But the title was open and in the glove compartment of the vehicle when it was seized.
Had the title been endorsed over to him?
It had been endorsed by Valley, the owner, and we've never even seen it because it's in the possession. I've never even seen it.
So it wasn't introduced into evidence, the title itself?
I don't believe it was. I don't believe it was introduced into evidence. No, sir.
So we don't, the record, at least as far as we know, I couldn't find in the record whether or not he had endorsed, whether Mr. Valley had gone to, endorsed it over either to your client or in blank. We don't know that.
All we know is my client's sworn statement in opposition to summary judgment is that the title to the vehicle that he had received from Valley was in the glove compartment at the time of seizure.
But, but his statement didn't indicate, and I'm really focusing on the evidence, well, this was decided by summary judgment, but the evidence, here's what I'm concerned about. The statute is clear. 319.22 says that no court shall recognize title or claim of interest to any motor vehicle unless evidenced by a certificate of title issued to that person. Now, there are some cases that talk about where somebody screws up and doesn't get the title done properly, but it seems like the case law and the statute says you're not the owner unless you have the title, with a couple of exceptions. And I think one of the exceptions might be if he had endorsed the title over to your client on the back, you know, or maybe it's on the front, you know, there's a place on the title where you can sign it over to someone. If he had done that, but we don't have any evidence one way or the other on that topic, is that right?
One piece of evidence, Your Honor, in the record now that I'm given the opportunity to think about it, and that is this. Also responded in our brief. If the document filed pro se, the letter purporting to be from Valley, it is from Valley in fact, and it is a part of the record. Valley late in this game, after the city has already claimed in their verified complaint that we are the owner and we're in possession, Valley 3 or 4 months later apparently gets served with the amended complaint and then says, I don't have any interest in this vehicle, I sold this to KLING. That record of that is in the
But
court file.
that doesn't address the issue one way or the other as to whether or not he endorsed over the title.
That is true to the certificate of title itself, sir.
And what I'm trying to focus on is, my understanding is that both the Supreme Court and the statute say primarily we're supposed to look at the title, and then there are a couple of exceptions, and those exceptions would be, I think in this case, clearly we're not dealing with a dealer, but if he had endorsed over the title, or if he had done some kind of paperwork and manifested an intent to convey the title but somehow had messed it up, an incomplete or a faulty conveyance. But what I understand is we don't have any documentation or any direct evidence that would suggest what happened to the title other than it's in the glove compartment.
May I explain why? Here's why we do not have that. What happened was at the adversary preliminary hearing, Judge Law, and we've set out, shouldn't have been assigned to the case, ruled in KLING's favor in the adversary preliminary hearing. Then the city filed a motion for rehearing, and Judge Law later, way later in August or something, late, a month or more, did an order finding probable cause. But 2 days, back in July, 2 days after the motion was filed, the city files its verified complaint, and in it alleged KLING to be the owner and that KLING to have possession of it at the time of its seizure. At that point, sir, I believe that we shifted out of the adversary preliminary hearing phase into the trial of they admit we're the owner, they admit it is seized from us, if notwithstanding we don't have the certificate of title because the title is being held with the vehicle. Whatever it is, whether it's, and we never saw it because we skipped into the discovery portion of that, and as that was developing, what happened was there was a mini complaint file, sir, and in it simply says, well, KLING claims ownership. We then 2 days later admit that and was in possession at the time of its seizure, which is the Jimenez case, I believe we cited in our brief, saying that's right, so we are entitled.
You're essentially saying that ownership was established by their concession?
I think I believe it is, yes, but I also concede that when they amend, which they have a right to do, then that created problems for us, because then they said, well, we just claimed title. And then that forces us back to the fact that we are clearly here able to establish that we're the equitable owner and the sole person entitled to this vehicle. And if it is seized, what I'm looking for here, sir, is I think there is an exception.
So you're saying equitable ownership or equitable right to ownership is sufficient rather than legal ownership, which requires a title?
I think
And that's sufficient?
I'm sorry. I think we fall into the comments by Judge Overton in one of the cases cited, and also the comments of Judge Barquette, who, and they're cited in our brief, that if in fact, the Overton, if I could, in the Lamar case relied upon by Appellees, states that he had concurred in the result that was reached related to 3/19/23, but there's no mention of the grace period in which our vehicle was seized. Our vehicle was seized before.
The statutes say you've got 30 days to apply for the title, or some period of time, but normally when you go to a dealer, the dealer takes care of all that. But in this case, I guess I'm trying to focus on your client would have been the owner under the title if they had endorsed the title over to him, or he held it endorsed in blank. But we don't know either way on that.
We never got there, no, sir.
Right.
Because
And Justice Barquette's comments are in a dissent, if I recall correctly.
But I think
But let me interrupt. Isn't it if you want to contest the forfeiture, isn't it your burden to show that you have standing and to show that you have legal title? And if you didn't meet that burden, you don't have standing.
Well,
So how did you meet your burden?
under Jimenez, Your Honor, in which we showed a proprietary interest. And we showed when Valet filed his document.
If I say that a proprietary interest or beneficial interest is deficient, it's got to be legal title. Were you able to establish that you had legal title to the vehicle in order to acquire standing to contest the forfeiture?
I do not have it because we were precluded by the conduct of the city from obtaining the legal title because it was seized with the vehicle, we say, within 2 or 3 days of the trade.
You essentially are claiming that you're the equitable owner of this. Isn't that something that's already been addressed squarely by the Florida Supreme Court in Lamar?
Judge
That
Tynan,
those circumstances that you can't claim that you're the equitable owner and
What-
get standing.
I'm sorry, sir. It has been addressed in the Lamar case. Justice Overton, and he concurred only in the result because we didn't talk about this 30-day grace period, but what he says is, he, reviewing the whole record, found that the claimant was not an innocent person, or that they had no equitable claim. Here we
Client
could,
in the same position.
Sir?
Isn't there a statute that requires at the time of the transfer that there be some signing by your client, and if it's a violation of the law, not to do so?
I believe that is covered by the citation of authority that we put in our brief, sir, that gives us the 30-day period of time to perfect our title. What we don't have is any case where a vehicle has been seized. If you look at this, Judge Tynan, if the city of Leesburg could pick up a car coming out of Cecil Clark Chevrolet driveway while the title is in the works and claim a crime was committed, and there would be no standing under the decision of KLING. Do you understand what they could do that?
Well, my point is 319.22 subsection 5 says that it's illegal to transfer title of a motor vehicle when the purchaser's name does not appear on the title. You're claiming that your client hasn't done anything improper, that it's the city that's holding on to this piece of property that doesn't allow you to transfer the title, but there's no indication that your client has complied with the law that requires him to sign or have his name appear on the title at the time that the transfer was done, which you purport was 2 or 3 days prior to this particular forfeiture.
And the only way that we would be able to do that is have the court held a hearing to allow us under Jimenez to establish that we are the owner. And again, I have to concede, Judge Sawyer and Judge Orfinger, that again, it would just show that we are the equitable owner of the interest in the vehicle and have a proprietary interest.
Did you take steps to try and obtain this certificate or a copy of it from the city? For example, go to the court and say, Judge, we need to have this provided to us through discovery or through whatever, have them subpoena or whatever to get a copy, or have them bring the certificate of title in so we could establish on the record what was on the certificate of title and who it was endorsed to?
We never got there, sir, because the summary judgment was entered notwithstanding the client's affidavit that he could prove that he was the owner of the vehicle but could not transfer. And on that issue, Judge, if I could, Judge Swy, there has been issues where in cases, remember an airplane case, another one cited in our brief, where if you go try and perfect a title, it's not going to work anyway after the date of the seizure. It might even be fraud on the city of Leesburg for us to go try and perfect that title, because the vehicle has been seized and the sole remedy is through the forfeiture proceedings.
Really what it comes down to is if we accept the idea that equitable ownership is enough, you would be okay, and if we accept the idea that that's not enough, you're out of luck.
I'll guarantee you, if we recognize that a person with a proprietary interest and equitable ownership sole of that vehicle, I'm going to prevail in the trial of this case.
All right. I think we've got it. So if you want to hold your remaining time for rebuttal.
I'm not one to quit, Judge. Thank you all.
Yes, sir. Okay, please, the court. All right, counsel, I think we've kind of reduced this down to its basic, and that is, A, does the record show us what the status of the title is? Do we have the document to see in the record that it was or was not endorsed over by Mr. Valley over either in blank or to Mr. KLING? And secondly, if the record is silent on that, is equitable ownership enough?
As to the first question, Your Honor, the record does reflect, now the title was not entered into evidence at the hearing on final summary judgment, but it was addressed on page 6 of the transcript from the summary judgment hearing, starting on line 19. So in short, Your Honor, in the instant case, the record title holder of the vehicle was Juan Alberto Gomez Valles. And if you take a look at that document, I was referencing the title, there's no mention on the bottom of it as to who the purchaser was, when it was purchased, none of the back is filled out, and all of this is required by Chapter 319 to be completed at the time of the sale. So although the title itself was not introduced into the record, we have my argument, and I did in fact show Judge Hill a copy of the title, and I believe Mr. Hatfield saw a copy of it as well. As to the issue on equitable ownership, I agree with what you said. Lamar and both Lamar, Byram v. Gallagher, Lockheed, they all said that in order to have standing to contest the forfeiture stage, which is the second stage, that you must be the legal title holder of that vehicle or have taken steps to obtain title.
Okay, so your position, if to summarize, is equitable title isn't good enough and that he didn't take any steps, there's no endorsement, faulty or otherwise, there's no endorsement on the title. And
correct.
You think that the argument that you made, and I guess a reasonable implication is that you were looking at the title at the time, gets you there?
Correct.
All right. Any other questions? Questions? All right, thank you, sir.
Very briefly, response. Your Honor, the document I referred to from Valet is found at page 59 of the volume 1 of the index. And again, the mention was made, this isn't between dealerships, these are unsophisticated people. Our argument is that if we could establish a proprietary interest, if the government is seeking to forfeit something of value, then we should be entitled to defend that equity and require them to prove that a crime was committed that would support the extradition and forfeiture of that vehicle to the city.
The opposing counsel just indicated that at the hearing that the title was referred to, and actually, I think he said the judge was shown the title, and that it did not have your client's name on it, and it wasn't endorsed or in any way signed over to your client.
I cannot dispute that, Your Honor.
You dispute that?
I cannot dispute that. No.
At that time, you could have requested that a copy of the certificate of title be placed before the judge into the record, and you didn't do that either, did you?
I failed to do that.
Pardon?
I did not do that.
Okay.
All right, sir. Well, I think we understand the
So
argument.
your basic argument is now that it's beneficial ownership that gets you there, and that should be sufficient for...
Proprietary interest and the equitable ownership.
All right.
All right, sir. Thank you very much. Thank you both.
Thank you.
All right, we'll call the final